Start. In the matter in hand, it is not disputed that petitioner had remarried after death of her first husband, therefore, her claim cannot be recognized under law as discussed above. Stop. Claim of Srimati Choti within bracket respondent number 1 bracket out being successor of Bipin should be preferred over the claim of present petitioner, who had remarried. Stop para. In the case of Par Santi under bracket Supra, Honorable Apex Court has accepted the plain and simple meaning of court mother D court as used under section 171 under bracket 2 under bracket B of UPZA and LR Act and expounded that widowed mother, who has remarried cannot lay a claim to the property of her son through the first marriage. Stop. Relevant para 2 of the aforesaid judgment is quoted below para quote. The only question which arises for consideration is whether a Hindu widow who after the death of her husband remarries another person can lay a claim to the property of her son through the first marriage, if that property happens to be agricultural land. Stop. The learned counsel for the appellant placed reliance on a decision of a 3-judge bench in Kasturi Devi versus Deputy Director of Consolidation, under bracket 1976 4 SCC 674 under bracket 1977 2 SCR 25. Stop. This court applying the general law under the Hindu Succession Act, 1956 and on principles governing Hindu law answered the question in the affirmative, stating that in such a situation she is no claiming as the widow of her first husband but is laying a claim as the mother of the predeceased son. Stop. Their lordships did not apply the provisions of the UP Jamindari Abolition and Land Reforms Act, 1950 in the facts of that case of their lordships. Attention was not drawn to the special law. Stop. Section 171 under bracket B whereof, in terms, excludes a widowed mother, who has remarried. Stop. The plain language of this provision in the special law, therefore, clearly excludes the widowed mother, who has remarried, from claiming a share by inheritance from the property of her son born out through the first husband. Stop. That being so, in the facts of this case, the decision in Kasturi Devi case does not apply. Stop. In that case, this court was not applying the provisions of section 171 under bracket 2 under bracket B of the UP law. Stop. We are, therefore, of the opinion that the authorities below were right in holding that in view of this special provision, her claim was not justified. Stop. D court para. In this conspectus as above, I do not find any substance in the submission made by counsel for the petitioner, who has failed to point out any illegality and perversity in the order passed by all the 3 consolidation courts. Stop. Claim of present petitioner has rightly been discarded by the consolidation courts. Stop. Being remarried mother, she has no claim over the agricultural property of her son, who was born out of wedlock with the previous husband. Stop para. Present writ petition is devoid of merit and accordingly, it is dismissed. Stop.